Changes to New Zealand's work visa scheme that has kicked off in April signal a bold, if not overdue, move by the government to supposedly tighten the reins on employer accountability and safeguard migrant workers. But does this address the true root of the issue? Or is it merely, as critics argue, a cosmetic change, window dressing on a shop front that's falling apart? This reform includes, among other things, the introduction of a minimum English language requirement for certain roles. On paper, this sounds reasonable, right? Aligning with international standards as seen in countries like Australia, the UK, and Canada. It's meant to empower workers, ensuring they understand their rights and can report exploitation effectively. The new English language requirements, though seemingly step in the right direction, have been criticised for merely increasing bureaucracy without genuinely safeguarding the workers from exploitation. It's like adding a new lock to a door while leaving the windows wide open. Critics argue that high level of English proficiency haven't prevented exploitation elsewhere, particularly noting past issues within the student visa system, and the issue of job check tokens. This remains a massive loophole. These tokens, which employers obtain to prove they have a genuine job offer for visa applicants, have become a commodity in themselves, traded and sold and feeding into a cycle of exploitation rather than preventing it. Despite the new measures, the system still allows for this trade, barely scratching the surface of the real issue at hand. This scenario suggests a disconnect between the policy's intent and its impact on the ground. This ongoing exploitation within New Zealand's immigration system isn't just a policy flaw, it's a systematic failure that requires a comprehensive overhaul, not just piecemeal tweaks. What's needed is a robust and transparent system that severely penalizes bad employers while genuinely protecting the rights of migrant workers. If the government continues to rely on employers to self-regulate, how can we expect any real change? And with the promise of future reforms, one must wonder, will these be yet another round of marginal adjustments? Or will we see a significant pivot towards real accountability and protection? As we look forward, the effectiveness of these reforms will undoubtedly be under scrutiny. The government finds itself at a critical juncture. Will it step up and make the bold decisions necessary to protect its migrant workforce? Or will it continue to offer half measures that leave many vulnerable? For now, skepticism remains high and hope for the real change hangs in the balance. The government's next moves will be crucial in determining whether we can finally close the book on exploitation or if this chapter will drag on, mired by the same old problems. As always, action speaks louder than words, and it's high time for action.